Hi, my name is David Cohen. I'm a professor of law at Drexel University's Klein School of Law. I wrote this book, Obstacle Course, The Everyday Struggle to Get an Abortion in America, with Carole Joffe, a sociologist in California. We wrote this book because we thought it was important for people to be able to understand all of the restrictions that people who want an abortion have placed on them by state legislatures or courts, from the moment they find out they're pregnant to the moment they get an abortion and every step in between. These stories are important right now because abortion is becoming even more and more regulated. In some states, they're going so far as to ban abortion, even though that's not allowed under Supreme Court rule right now. But also because the Supreme Court is at a tipping point. With the replacement of Justice Kennedy with Justice Kavanaugh a year and a half ago, we have what we think is an anti-abortion majority on the Supreme Court. Now, how far they're going to go in allowing states to regulate abortion even more or make it illegal, overturning Roe v. Wade, we don't know. But they have a new abortion case on their docket. And what they do, this new set of justices or this new conservative majority around abortion, is a big unknown. So we thought it was important to tell these stories now to sort of convey how difficult it is already, in the hopes that it doesn't get worse. I think the overall finding of the book that I think is most surprising is that even in a world in which Roe v. Wade is good law, because it still is, that throughout the country there are many places where it's already really difficult, almost impossible for patients to get an abortion. They have to jump through so many hoops, and that's with Roe on the books. If Roe were ever to be overturned, it would be even worse. So putting it all together and showing how in this world with Roe, it's really difficult for a lot of people would surprise, I think, a lot of readers. I think for both me and my co-author, Carole Joffe, we think it's really important to document and analyze the ways that what should be seen as a normal medical procedure, very common, very safe medical procedure, the ways politicians use it as a political football and interfere with it. We both have been she's been doing it a lot longer than I have, but we've both been doing it a long time, and we see the commitment of the providers to still provide great care, and that's the kind of thing we want to document, and also the patients, to talk about the way patients are so committed and focused on getting the care they need that they're able to, a lot of them, jump through these hoops at high costs to themselves, but it's really for them. It's for the providers and the patients that we do this work. Over the last decade, we've seen some big changes in abortion regulation. In particular, since 2010, just the volume of anti-abortion regulation around the country has been unprecedented. We've also seen, as evidence in 2019, states that are trying to ban abortion at even earlier and earlier gestational ages, 6 weeks in some states, or Alabama, from the moment of conception. These are clearly unconstitutional. But the hopes of these states is that they will get these laws to the Supreme Court, and the Supreme Court will overturn Roe v. Wade or allow them to all but make abortion illegal. So the states are getting more brazen in trying to challenge Roe v. Wade. And up until now, the courts have provided some amount of a backstop, but that could change. Public discussions around abortion have changed a lot, especially in the last decade or so. What we see, particularly on the side of abortion rights advocates, is more people willing to speak out about their experience getting an abortion. We have movements, the We Testify movement, Shout Your Abortion, people being very public on social media, in the press, about how important it is to have an abortion, that their abortion was in their lives, and being able to access future opportunities or to get the medical care they needed. We've also seen a change in the recognition of abortion access and race and the connection between the two, and how a lot of the restrictions that Carole and I detail in this book disproportionately impact women of color. throughout the country. And so when you talk about abortion access, we have become increasingly aware that what we're really talking about is racial justice as well as reproductive justice. The justifications for abortion restrictions that we've seen from state legislatures that have restricted it even further try to use the mantle of protecting women more now than they used to. It used to be that the state legislatures would talk about protecting the fetus, and they still do. But more recently, we've seen state legislators trying to take on the mantle of feminism, that we're doing it to protect women. We're trying to make sure women make an informed choice. And we want to protect them from the unscrupulous doctors and medical care professionals who work at abortion clinics. These are all just based on myths about abortion doctors and abortion providers only in it for the money, which is just a lie. This is not a high money profession at all. It also, the state legislatures who have used these justifications have forced doctors and other medical care professionals in an abortion clinic to tell patients lies under the guise of protecting women, protecting the patient. State legislatures have forced doctors to tell patients that abortion causes suicide or breast cancer or depression. None of these are supported by medical evidence. But the reality is, what this means is that doctors are literally lying to their patients right before medical procedure. But that's what state legislatures are doing now. The Supreme Court is very important in the contemporary abortion debate because it sets the backstop that states cannot go below or go beyond. So Roe v. Wade says that states cannot make abortion illegal. Planned Parenthood versus Casey, a 1992 case, says that states cannot unduly burden abortion. Obviously, that term, unduly burden, is subject to interpretation, but what it means is that as the Supreme Court looks at these laws, it will stop states from going too far. Now, if the Supreme Court were to change these rules and allow states to impose even more restrictions, or allow states to make abortion illegal, that would be a monumental change. It is only because of Roe v. Wade that abortion is legal, although difficult to access, but legal still in every state in the country and every territory. And that's hugely significant. So it's hard to understate how important the Supreme Court is with respect to abortion policy in this country. State courts and state constitutions also play a major role because even if a law or a restriction around abortion is okay under federal constitutional law, it might violate a state's constitution. And we've seen that in various places in the country and some surprising places. So for instance, last year in Kansas, a deep red state, the Kansas Supreme Court found that its constitution protects the right to abortion and prohibits the state from imposing some of the restrictions that we talk about in our book. And so state constitutions, state courts can also protect the right to abortion beyond what the U.S. Supreme Court does and the U.S. Constitution. We've seen that in not just Kansas, but many states around the country. And if the Supreme Court, the U.S. Supreme Court, were ever to overturn Roe v. Wade, you would see more and more advocates going into state courts and trying to get state courts to protect the right. So in many ways, this book is depressing because the reality is that states have put all these restrictions in place and made it really difficult for patients to access care. But in other ways, we hope that we've told a story that is uplifting of both providers and patients working together to still provide care and high quality, safe care in this really difficult environment. And also to show that there is a better way. There is a way that we see, a better way that we see in some states where patients can get the care they need, whether it's pregnancy care, gynecological care, or abortion care from the same doctor, the same visit. without insurance problems, without encountering protesters, without the state legislature telling their medical care professional, do the procedure this way, not this way, that you know is within your expertise the right way to do it. There is a better way. There are states that are doing that, and we did try to highlight that in this book, so that people aren't left just feeling like it's hopeless, but rather that in a better future, hopefully sooner rather than later, abortion will be treated the way it should be, which is another medical procedure that is safe, that is legal, and the medical care professionals should figure out how to provide that care, not state legislatures. Advocates working on this issue really need to work on all the different levels you can. So that means courts, that means legislatures, that means community organizing. They all go hand in hand. The courts need to be there as a stop when states go too far. But the courts alone can't improve access. What the courts can do is prevent bad things from happening. But in state legislatures, even local legislatures, you can improve access, you can make things better for patients. But then you need community organizers to make sure it's a reality on the ground, to fill some of the gaps where the gaps exist. And you see these around the country. You see these sort of confluence of courts, legislatures, and community members working together to make sure that patients are treated with dignity and that patients can get the medical care that they want and need. It shouldn't be this way. Abortion, as Carole and I write in the book, should be treated just like any other medical care procedure. We're not arguing that it shouldn't be regulated. It's just that it should be regulated like other fields of medicine, and you shouldn't have all of these extreme restrictions in place just for abortion.